All right, some legal issues now. And for that, we are joined by Bill Aronwald, criminal defense attorney and former chief of the criminal division of the U.S. Attorney's Office for the Eastern District of New York. Bill, nice seeing you again.
Nice seeing you.
All right, help us out with this one because we go to Texas, and there's outrage there after a juvenile judge sentenced a 16-year-old boy this week to 10 years probation, no jail time, for intoxication manslaughter. It was a crash that killed 4 people. Now, prosecutors, they wanted 20 years in state custody for the Keller teen, but his attorneys argued for rehab instead of imprisonment. Eric Boyles, who lost his wife, daughter, he told the Fort Worth Star-Telegram that the family wealth helped the teen avoid incarceration. Defense argued the boy suffered from affluenza, claiming his family wealth made him irresponsible and exercised poor behavior. That's a unique defense. Now, just to show that this is not universally the sentencing that usually happens, we go to Newburgh, not too far from us, where a man there was sentenced to the maximum, between 12.5 to 25 years for a deadly drunk driving crash. He had originally claimed that he wasn't driving. The judge thought otherwise, calling him one of the most unsympathetic defendants he'd encountered. The point is, I know one's a junior and one's an adult, but how much discretion, does it matter district to district, state to state? How much discretion does a judge have in deciding who deserves to get a pass in effect, get probation, and who gets the book thrown out?
Unless you're in a state that has mandatory sentencing where the judge has no discretion, as long as it's discretionary, they can give anywhere from straight probation, 0 time, to the maximum, as we see in these 2 cases. I mean, this defense of affluenza, I mean, it doesn't even pass the laugh test, much less the smell test. I mean, I've been doing this for a lot of years, and I mean, I've heard a lot of explanations, but to come in and say, you got to give my guy leniency because his parents are just too rich, you know, it makes no sense at all. I mean, and it's really sad because, I mean, you have to wonder what this judge was thinking. You have a 16-year-old kid, okay, you give him a little bit of a break because he's young. Yeah. He blew .24, 3 times the legal limit. He had Valium in his system. The beer that he had been drinking, he had stolen. 4 people killed and other people, you know, permanently injured and maimed. And then you take the Newburgh case where basically he was 47, okay, he was an adult, but he blew .15. And he had cocaine in his system. So there's a striking similarity between the 2 cases other than the age, and yet you cannot reconcile. There's no way to account for why in the one case he gets probation, and in the other case he gets a maximum penalty. And that's one of the things that sort of makes people take a look at the criminal justice system and shake their head and say, there's some imbalance here.
One quick difference, Texas elected judges. Just throw that out there.
And I think also in Texas, like other states, judges can be impeached, and this judge, I would think, should be impeached. I don't see how she can possibly justify giving this kind of a sentence. You know, and the parents, through the lawyer, said, well, we're going to put him in a rehab center. It's going to cost $500,000 a year. No one is suggesting he's going to be in that rehab center for 10 years. No. You know, and so it really is.
By the way, a rehab center a lot different than going upstate or wherever they are. It also, I mean, we saw that case. Remember with the case with the minor was with the adult, and the judge basically said, you know what, she kind of seemed like an adult to me. Now, he's going to be pushed out, but I think the public is under this impression that the sentencing guidelines are far stricter than they actually are, and judges don't wield the real power that they do. So,
well, you have to understand, in most states there aren't any sentencing guidelines. Sentencing guidelines is sort of a federal situation, and those guidelines are not even mandatory. Judges now can consult the guidelines, but they don't have to follow them. But there are other states like New York which do not have codified sentencing guidelines.
It's amazing. All right, now this next case, and I think there's a sympathetic aspect, but then where does the line start and stop? A mercy killing in California. Man shot, killed his wife, suffering from dementia. Then he killed his sister, who was a patient in North Hills convalescent home. Police allege that this man killed his ailing wife at their apartment, then drove to a nursing facility, and his sister, who was in a near comatose state, was then killed. He then dropped the gun, waited for the cops to arrive. By all accounts, his sister and his wife were in terrible physical states. We come back again to discretion, but at the same time, we don't let people take the law into their own hands. But you're trying this case and you're defending this guy. The jury is going to be sympathetic to you. How do you make the case that it's terrible, he shouldn't have done it, but if you were in the same shoes, you'd understand? Could this guy walk?
Well, there's a concept called jury nullification. Jury nullification is where you basically argue to the jury that the circumstances in this case call out for an acquittal, even though the law may not. Unfortunately, you're not allowed to really use the buzzwords jury nullification. You can, as a lawyer, argue to the jury, forget the law, ignore the law, just do the right thing here. But you have to do it in a very subtle, artful way. This is a kind of case where if I was defending this fellow, I mean, because it's really a sad case. His sister was in a vegetative state. His wife was suffering from dementia. He's 60 years old. We don't know whether there was any other caregiver in the family for the sister. We don't know whether he himself has some health problems, which indicated to him that he was not going to be able to care for both people, much longer. This is a kind of a case where you'd like to see the justice system do the right thing, and that would be what kind of punishment is enough? And I would think if I was his lawyer, I would be looking for some kind of a disposition which keeps him out of jail, because I don't think this is a kind of a case where he should go to jail.
Well, let me ask you two. I put you two guys in the jury with the facts that we know now. Would you think this guy, though you sympathize, still deserves to be behind bars for what he did, or would you say probation with restrictions is enough?
I honestly do agree with Counselor, the way he just said it. In terms of the lawyer, you've got to stick to the law. You're trying to find an artful way to get around it. It's up to the judge. If you're asking me, Dominic, be specific, I don't think he should go to jail.
Andrew?
I agree based on what we know. You never know what else we might find.
It does set an interesting precedent, though, or at least, you can kill if it's for a good reason. Anyway.
Well, that's the problem. The problem is, what kind of message do you send, because it sets a precedent. Than any other person. Well, I did it because...
What if it's not near vegetative? And what if it's not really comatose, that they're sick and they got cancer? Yeah, I mean, it opens up all these things. Bill, as always, I appreciate it for you. Thank you very much.
Have a good
guys.
year.
All right, when we come back, we will switch gears. As we know, we're approaching the anniversary of the tragedy in Newtown. We come back, we'll talk about protecting our kids and also a very emotional conversation with a Newtown dad.